Hello and welcome to the Washington Entity Regulation Pilot Web Snack, Part 2. Thank you all for the chance to speak with you. I'm Craig Schenk. I've been invited here because I'm a volunteer with the Washington Supreme Court's Practice of Law Board, but views are my own. We're going to talk today in more detail about the Washington Supreme Court's Entity Regulation Pilot. Remembering that Part 1, that was all about why. Where did the Entity Regulation Pilot come from? Part 2 is about what. What is the Entity Regulation Pilot, and how will it work? I'm really excited to have a few minutes of your time. So let's go back to the Entity Regulation Pilot Order issued by the Washington Supreme Court on December 5th, 2024. Under the order, the Washington State Bar Association, together with the Supreme Court's Practice of Law Board, will develop and operate the pilot, all under the oversight of the Supreme Court. Entity regulation means that for the first time, entities, including nonprofits, law firms, multidisciplinary groups, can apply to deliver legal services. Authorizations will be issued by the court under time-limited exemptions from specific rules. Now, what does that mean? Entities with innovative business models, including those operated by individuals who wouldn't be licensed to practice law, they can offer legal services based on carefully evaluated, monitored exemptions from specific rules governing the practice of law. It's a 10-year evidence-driven experiment to learn what works and what doesn't. It's a unique platform to test new ideas. But entity regulation is kind of a mouthful, and it sounds technical. So just to be really clear, entity regulation is how we, as a state, will experiment with authorizing legal services delivery across a range of different innovations, whether that might be empowering social workers to deliver relevant legal advice in their daily work setting, building new, broader capabilities within legal aid groups, extending the capacity of law firms with new technologies or innovative partnerships or business models. So, Craig, you talked about platforms to test ideas and all this innovation stuff. This sounds like you're focused on technology, right? No. It's really important that I get across that technology innovation certainly has potential, but the pilot is not meant to focus on a given technology or on technology at all. Let's look at some innovation in other jurisdictions over the past few years for some examples and some inspiration. Now, here's one that's licensed in both Utah and Arizona, and that's Raza Legal. Raza uses a combination of technology and non-lawyer specialists to conduct highly effective, highly cost-effective as well, criminal records expungements, very low cost. Raza is a public benefit corporation that took investor money to enable the technology work to support the project, which would not have been permissible under Rule 5.4, just as the non-lawyer specialists would not have been permitted under the UPL rules. Also from Utah, a program run by Timpanogos Legal Center trains non-lawyer community advocates specifically to assist clients seeking domestic violence protective orders. Innovation for Justice has recently trained community-based non-lawyer advocates working for Holy Cross Ministries to provide limited legal assistance in medical debt collection. In Alaska, a very impressive program of community justice workers building on learnings from community health workers have authorized and trained non-lawyer specialists capable of helping Alaskans who don't have ready access to lawyers through a range of specific legal issues in their communities. These all just scratch the surface of what's possible through innovation programs like the pilot. Now, the room for creativity is not unlimited. The pilot creates exemptions from rules, but not from consumer protection. As you think about this, think about for your own work, each applicant is going to need to propose a clear hypothesis about how their model could expand access to legal services and ways to test that hypothesis. They're going to have to designate a compliance officer. They'll have to submit to rigorous oversight and data reporting. Each authorization is going to be time-bound and closely monitored. Participants will also deliver data to evaluate whether the program is achieving the objectives that the Supreme Court developed in the first place. Now, this is all implemented through an online application that builds on the Washington Supreme Court order all the depth of experience that WISBA has in managing a licensing process, and also industry-established norms for risk evaluation and risk management. Applications will be analyzed and reviewed by WISBA staff and then by the Practice of Law Board before recommendations are delivered to the court. The Supreme Court has the final say for each application. This is a trial. It's an experiment. It's an incredible opportunity to learn more about what works and how we can deliver legal services if we remove some of the existing constraints without losing focus on protecting consumers. We don't know exactly what will come out of the pilot. That, indeed, is up to the community, the innovators, and the market. It's up to all of you. But I do think it represents a significant step forward in our journey to explore innovative approaches to licensing and regulating legal services, allowing entities, not just individual attorneys, to deliver certain legal services. I encourage you to learn more, find your opportunity, and apply. Much more is available on the website. I encourage you to sign up there to get onto the email list. You'll also find an email address to get specific questions answered as needed. So, that's the end of the Washington Entity Pilot WebSnack Part 2. Again, I encourage you to learn more, sign up, and please come build the future. Have a look at Part 3 if you'd like to learn more about engaging with the pilot. Thank you for the chance to speak with you.